put it in the record?
And I can only take a verbatim. I can only take a record of someone.
Okay, so I need to read
You could
it.
like enter it as an exhibit, but I couldn't like make a record of it.
Yeah, that's a good idea. I'll just read it out loud and then I'll send it to you so you can make sure you write it down right.
Yeah.
So you'll have it.
Yeah, unfortunately, we can't make a record off of a piece of paper, but you can enter it as an exhibit, and it would be attached that way. Sorry, what's your name, please?
Allison Russo, R-U-S-S-O.
Just let me know when you're...
Okay. You want me to swear her in first, or do you want to do that first?
Yeah, you can go ahead and swear her in and I'll...
Okay. Would you raise your right hand, please? Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Prior to today's deposition, plaintiff and I entered into a stipulation that would govern this deposition and the deposition of David Myers earlier today. I'd like to read that into the record. So one is plaintiff Elliot Forhan has served a notice to take the deposition of Representative Allison Russo and David Myers on Friday, February 27, 2026. Defendant's counsel Stephen W. Funk was not available on Friday, February 27, 2026 because he was previously scheduled to be out of town on that date, but was willing to reschedule the depositions of Russo and Myers to the following Thursday, March 5th, 2026. This rescheduling of the Russo and Myers depositions was undertaken based upon the fact that Mr. Funk was out of the state on February 27th and should not be construed as being any agreement.
And should what?
And should not be construed as being any agreement by defendant to extend the discovery deadline. With respect to the depositions of Representative Allison Russo and David Myers, defendant will agree that plaintiff may record the depositions subject to the following conditions. A, there will be an official court reporter present who will be responsible for preparing the official transcript of the depositions. B, Forhan will announce on the record when he is commencing recording and when he is stopping recording, and will not record any off-the-record conversations. C, Forhan will agree to provide a copy of his recording to defendant's counsel. And D, Forhan will not seek to use his recording as evidence in the case, but will agree that the official transcript prepared by the court reporter will be the only transcript that could be used by the parties. This stipulation applies only to the recordings of the Russo and Myers deposition on March 5th, and defendant reserves the right to contest the recording of any other depositions that may occur in this case. 3, defendant will agree that the transcripts of the prior deposition testimony of Allison Russo on March 21st, 2024 and March 29th, 2024 in the CSPO case may be used as evidence in this case, but only if Forhan will agree to not ask the same questions again in the deposition that will be taken on March 5th. Forhan agrees, therefore, that Representative Russo will not be obligated to answer any questions that were previously asked and answered by Russo, previously asked by Forhan and answered at the 2024 depositions in the CSPO case.
The 224?
The 2024.
The 2024.
2024. Okay, thank you. That's the stipulation. Did I read that accurately?
You did.
Okay, thank you.
We're ready?
Mm-hmm.
All right. Hello. Are you comfortable?
Yes.
Do you need anything?
No.
Can you describe your understanding of what a deposition is?
It's taking of testimony to use as evidence.
Do you believe that you are fully prepared to provide truthful and accurate testimony in this deposition today?
Yes.
How do you and I know each other?
You are a former member of the Ohio House of Representatives, a caucus of which I was also a member of the House Democratic Caucus, and I also served as the House Minority Leader while you were a member.
When did you and I meet each other?
I don't specifically recall, but I believe it was near or around your primary election.
Would that be in 2022?
Yes, in 2022.
Tell me about your experience with me to the present moment. Start from the beginning.
Objection, overly broad, but if you can answer it generally.
You were a member of the Ohio House Democratic Caucus for one term while I was the House Minority Leader. You were not reelected, and now you are involved in a lawsuit.
I want to enter first exhibit. Introduce first exhibit. So this will be number 1. Thank you.
Should have given it.
I assume the witness can use the exhibit marked by the reporter.
Mm-hmm.
Steve, is that okay?
Mm-hmm.
Okay.
Thank you.
You want to take a moment to look at exhibit number 1?
Sure.
So I'm going to give you some leeway here, but this deposition is not about asking her questions about Sarah Cherry. So how far are you going to go into this?
My deposition. Have you a chance to, are you still looking? Okay.
I'm sorry, what is the name? Sarah Cherry?
Sorry?
Sarah Cherry.
Like Cherry.
Cherry, that's right.
Although this is not about Sarah Cherry, this is another employee. Okay.
Do you recognize exhibit 1?
I recognize that this individual was a former employee of the House Republican Caucus as a legislative aide.
And when you say this individual, you mean Daniel Slaybaugh, is that correct?
Correct.
Yeah. Were you aware that this document, or sorry, I'll put it this way. Isn't it true that you were aware that this this document existed in the first half of 2023, right?
I do not recall that I was aware of this.
Do you remember when you became aware of the existence of this document?
I became aware of the existence of this document as a result of several records requests that actually were recent records requests from related to a former employee, Sarah Cherry.
Did you tell anyone that you fired Sarah Cherry because she was talking to the women in the House about Daniel Slaybaugh?
No.
Objection.
Did you tell Andy DePalma that you fired Sarah Cherry because she was talking to the women in the House about Daniel Slaybaugh?
No.
Objection.
Did you tell Andy DePalma anything about Sarah Cherry talking about Daniel Slaybaugh?
Objection.
No.
You emailed, I think this was toward the end of 2024, you sent an email. Isn't it true? You sent an email to the members of the Ohio House Democratic Caucus stating or implying that there was no evidence of Sarah Cherry's claims. Isn't that right?
Objection.
Do you have a copy of the email? I don't know which email you're referring to because you said end of 2024.
Well, okay, regardless of the timing, isn't it true that you did send an email to the members of the Ohio House Democratic Caucus stating or implying that there was no evidence of Sarah's claims?
Objection.
I sent an email to our House Democratic Caucus members in response to an email that Mrs. Cherry had sent that I was aware of to our caucus.
And your email stated that there was, quote unquote, no evidence supporting Sarah's concerns, right?
Objection.
Again, without seeing the email, it's hard for me to answer your question.
Did your email say something to that effect, to the best of your memory?
Objection.
To the best of my memory, the email explained that I did not believe that Mrs. Cherry's claims were substantiated.
At the time when you wrote that email, you were aware of this Daniel Slaybaugh discipline document, right?
Objection.
At the time of that email, I had not seen any of these records because this is not an employee of the House Democratic Caucus.
This document documents discipline of Daniel Slaybaugh for creating a, quote, hostile environment, unquote, right?
Objection.
Give
me a moment because could you refer,
could you point to
what it is?
One moment. So it's on the second page of the exhibit. In the second paragraph, first sentence. Some of your off-work behavior has led to the creation of a hostile environment. Do you see that?
I do see that. I have no context for the situation that this relates to because, again, this is not an aide or an employee of the House Democratic Caucus.
This document is evidence that misconduct occurred, right?
Objection.
Again, I don't have any context for why this was issued, so I can't make a judgment on that one way or the other.
The person who created this document is the Chief Administrative Officer of the Ohio House of Representatives. Is that not correct?
Objection. She doesn't have any knowledge of this document she's testified to.
I'm asking her
you
about...
can ask her what the document says.
Again, I do not have direct knowledge of anything that is written in this document, so I cannot assess what you are asking me to assess.
What is the job title of Kim Ziano Hartman?
Actually, I don't know what her official title is. Chief Administrative Officer.
Of the Ohio House of Representatives, is that correct?
Yes, that is correct.
And is her name, Kim Ziano or Kim Hartman, is her name on each of the first two pages of this exhibit?
Yes, her name is on pages 1 and 2 of the exhibit. That is correct.
Is it reasonable to conclude that she wrote each of these first two pages?
Objection.
Again, not knowing, because she is not a direct report to me, how these documents are put together or the circumstances, I cannot truthfully answer that one way or the other.
Do you think that these documents are forged?
Objection.
I do not believe these documents are forged.
Okay. To the extent that these documents are authentic, aren't they evidence that misconduct occurred?
Objection.
Again, because I do not have direct knowledge of this situation or this employee, I cannot assess one way or the other what occurred here. I can only assume, because this was written, that there was some circumstance that involved this employee.
Some circumstance. What does that mean?
Objection.
Again, I don't know.
Okay. Do you believe that there is no evidence that women are treated worse than men in the Ohio House of Representatives workplace?
Objection.
You'll have to
I believe
restate
that.
your question. It's
Okay, how about this?
using a lot of double negatives there.
How about this? Do you believe that there is any evidence that women are treated worse than men in the workplace at the Ohio House of Representatives?
Objection. Overly broad.
I believe that, or I don't, I want to be sure I answer, because again, your question as it's phrased is a little confusing. Can you restate your question?
Yeah. Do you believe that there is any evidence that women are treated worse than men at the workplace at the Ohio House of Representatives?
I do not believe that systematically women are treated worse than men at the Ohio House of Representatives.
So,
Objection.
to be clear, what you're saying is that you believe that there is no evidence that women are treated worse than men at that workplace.
Objection.
No, that is not what I
This
was
is
saying.
getting pretty far afield from the subject matter of our case.
Okay.
You're asking your political questions, and it's not appropriate in this deposition.
These are all related. All
No,
related.
they're not, and you know it. Get to the subject matter of the case, please.
Yeah. This is my deposition, Steve. I know that.
I'm going to make sure that you don't abuse it. So continue on.
Are you suggesting that I'm abusing my?
Yes, you are. You're taking advantage of the situation and asking political questions, and you know very well that has nothing to do with the subject matter of this case, which is you.
Yeah.
You're not alleging sexual discrimination. You're not alleging sexual harassment. So get to the subject matter of this case, please.
Okay. Again, Steve.
We're here to answer your questions, but not answer questions that have nothing to do with this case. So go ahead.
I read on the record during the previous it was less than an hour ago. I read on the record out loud the language of Division C of the 30th rule of the Ohio Civil Procedures, and I'll do it again if that's what it takes. Is that what it takes, Steve, for us to proceed with this
No, what it
deposition?
takes is for you to behave yourself and ask appropriate questions.
All right.
that relate to the
It
subject
sounds
matter
like
of
the
case.
answer. It's what you're saying. I'll tell you what I'm hearing. I'll tell you what I'm hearing. I'm hearing yes. That's what I'm hearing right now. So that's what we're going to do. Okay? Here we go. Okay, so this is Division C, the final sentence.
You do
of
not
divis-
need to
of
read
division-
it again.
of Division
I'm allowing
C2.
you to ask your questions. I'm asking you, as a professional who's an officer of the court, to ask appropriate questions in a deposition.
Listen,
You can choose not to do that, and I will object.
if you want to
But you
make
do not need to read me the rules.
if you want to make a motion under Division D, be my guest. But in the absence of that,
Ask your questions, and I'll object if they're
Steve,
inappropriate.
just so we're clear, I am not above asking the disciplinary council for help with you. I'm not above that.
Are you threatening me?
Yes, I am.
Okay, we'll note that for the record as well. That's also unprofessional. Go ahead.
There's nothing unprofessional about saying that I'm going to make a complaint to the disciplinary council if you're not following
You're
the
threatening
rules.
me to get advantage in a civil deposition. Go ahead.
I'm
Ask your questions,
Steve.
and I will object if they are appropriate for objection. I'm telling you to ask your questions, so I'm not violating Rule 30. Please go ahead.
Rule 30 says
You do
that
not have to read me Rule 30. What I'd like you to do is ask your questions. Please.
this is not going to continue this way. I'm not going to do this deposition this way, Steve. Okay?
Okay, as long as you behave, I will not, but I'm entitled to object to your questions. So if your questions are appropriate, I will object.
Okay. If we need, do we need to call the
No,
court
we
right
don't
the
need to
court
call.
right
I
now?
told them that you should ask your questions, so please ask your questions.
If you don't follow the rules, I'm going to call the court.
Fine. Just ask your questions. That's what we're here for. The questions should be about this case. Thank you.
I'm reading the first sentence.
Do not read the rule. Ask your questions.
An objection shall be stated concisely in a non-argumentative and non-suggestive manner. You are violating that rule right now, Steve. Stop it. Okay?
Could you raise your
Let me
voice
get
some
this.
more?
Let me get this on. Let's get on with it. I
know what it
need
feels
you.
like.
I need you to follow the rule that I just read, and I'm going to read it again. An objection shall be stated concisely in a non-argumentative and non-suggestive manner. Stop coaching this witness. Okay? Is this discipline document, which states that Daniel Slaybaugh created a quote-unquote hostile environment, isn't it evidence that he did create such an environment?
Asked and answered.
Again, I do not have direct knowledge of this circumstance, and I cannot answer that truthfully one way or the other.
I'm not asking you about the underlying events. I'm asking about the existence of the document. Isn't the document itself evidence of what it says?
Objection. Asked and answered.
Again, because I don't know the circumstances of this, I can't say one way or the other if this is conclusive evidence that he created a hostile work environment.
Okay, so to be clear, I did not say conclusive. I just said evidence.
Objection. Asked and answered. You can answer.
Oh.
Again.
Again, I don't believe that this is conclusive evidence one way or the other because I have no direct knowledge of this circumstance.
Okay, for the benefit of the witness, just so we're clear, there are only extremely limited circumstances in which your lawyer can tell you not to answer a question. To the extent that the lawyer wants to object,
She is answering your questions. You're lecturing her about nothing.
you told her, you just said her, just a moment ago, you said you can answer. She doesn't need to hear, she doesn't need your permission. I want to make it clear that she understands that. You don't need his permission, and in fact, you
I
have
will tell my witness how to answer your questions.
She's not your witness. She's my
She's
witness.
my client. So you ask her questions.
She's not your witness,
She will
Steve.
answer the questions. I'm sorry, I misspoke. My client. You ask her questions. She will answer them. I've not instructed her not to answer. Go ahead and ask your question again. You've asked it 3 times.
You do not need his permission.
Okay.
What conduct of Daniel Slaybaugh created a hostile environment?
Objection.
Again, I do not have direct knowledge of the circumstance, so I can't answer. I don't know.
Is it typical in the House that discipline documents would not contain the conduct, a description of the conduct at issue?
Objection.
Again, I have not looked at every disciplinary report of the House of Representatives, so I can't answer one way or the other.
Who is the victim mentioned in this document about Daniel Slaybaugh?
Objection.
Oh, it's on the second page. It's in the enumerated list. It's item number 2.
If you're asking who the victim is, I don't know. I don't see anyone identified.
No. What did Sarah Cherry complain about to the House in January 2023 that caused the House to engage the law firm Perez Morris?
Objection.
Well, I did not have direct knowledge of her complaint because she went directly to the legal counsel for the majority. She did not come through me, so I actually don't know what her original complaint was.
Sarah Cherry complained about inconsistent discipline. Isn't that right?
Objection.
Well, according to items that I've read after the fact, she did complain about disparate treatment. But again, I don't know what her original complaint was because I wasn't involved in that.
Sarah Cherry complained that women faced more discipline and more detailed discipline reports. Isn't that correct?
Objection.
Again, I only know that from the report as it was stated.
She complained about the content of discipline reports. Isn't that right?
Objection.
Again, I only know that that was part of her allegation based on the final report that was issued.
She complained that a woman was disciplined in retaliation for talking about Daniel Slaybaugh. Isn't that right?
Objection.
Actually, I don't recall if that was part of her complaint. I don't know.
She complained that that would discourage women from coming forward to report misconduct. Isn't that right?
Objection.
Again, I don't recall if that was detailed in the final report. I don't recall.
The House engaged Perez Morris to do a workplace investigation into Sarah Cherry's complaint. Isn't that right?
Objection.
That is correct, yes.
Complaining about discrimination against women in the House is part of the work of the House, is it not?
Objection.
I
Far
don't
afield from this
entirely
case.
understand your question. Say that again.
Complaining about, let's say, for example, that discrimination against women in the House workplace is happening, then complaining about that discrimination would be part of the work of the House to eliminate that discrimination. Isn't that right?
Certainly, every employee is entitled and encouraged that if they feel that they are receiving discrimination, then they should make a report of that.
Yeah, so it is part of the job, making and handling complaints. Isn't that right?
I would not describe, well, I guess clarifying question, part of what job?
Working at the House.
I would not describe it as part of the job. I would describe it as it is the ability of employees to complain if they feel that they are being discriminated against.
So you think it's not part of the job to eliminate discrimination in the workplace at the House?
Objection.
That's not what I said.
Tell me what your view is.
I said I wouldn't describe it as a job description. It is part of, as an employee, you certainly have the right to complain if you feel that you're facing discrimination.
And, so you have the right. In your view, I mean, isn't there more, especially with respect to, people who are in positions of leadership within the workplace, isn't it the responsibility of people in positions of leadership in the workplace to, ensure that no discrimination of that sort is happening?
Again, it is my perspective that every employee and member of leadership has a responsibility to identify if discrimination is happening.
Let's take a break, 5-minute break. I wish you'd get the subject matter of the case. Can you announce on the record you turned off the recording?
Yeah, I'm turning off the recording. I turned mine back on. That's okay.
We're back on the record. I just want to state from the record that I object strongly to any line of questioning relating to Sarah Cherry and the allegations that she's made. There is a pending EEOC proceeding that's going on. I do not represent the General Assembly in context of that EEOC proceeding. And this is an effort by Mr. Forhan to obtain evidence for use by Sarah Cherry in her EEOC proceeding, and I object to that. I'm going to allow the questions to be asked, but I'm going to continue to object. And I just want to state for the record that it's outside the scope of this case for him to use his deposition to gather evidence that would support Sarah Cherry's EEOC proceeding. Thank you.
I will also say, for the record, that at least one of the things that Mr. Funk just said is false. That being the allegation that I'm pursuing this line of questioning for the purpose of helping Sarah Cherry's case. That's false. As we were just discussing off the record, this has only to do with supporting my own case. So, and oh, by the way, only the judge, Steve, has the power to say that this deposition is over. And again, if you want to make a motion under Division D of Rule 30, be my guest. So other than that, it's not within your power to permit the deposition to go. The deposition will continue regardless of your feelings about it. Okay, if we may. The time that Sarah Cherry spent working on her complaint and the handling of her complaint was time spent working, right?
No, I do not agree with that.
Why not?
Well, first, I don't know what you mean by her complaint. There was an outside counsel that was hired to investigate her complaint. It wasn't her that was hired to investigate the complaint.
But she spent time, like writing down the things that she included in her complaint, right?
I have no idea what she spent her time on.
Well, I mean, she did make a complaint, right?
She made a complaint in January of 2023, I believe. And then it was handed over to outside counsel to investigate. So again, I don't know what she was working on in regards to that complaint.
Well, my question is, the time that she spent making the complaint, that's all I mean. And then the handling of the complaint, she wasn't the one who was doing the investigation, but there were other people who were involved. I believe that she made it to the chief of staff of the Republican caucus at the time, if I'm not mistaken. So there were other people who were involved, right?
I don't entirely know what the process was, but certainly she made an initial complaint in January. Don't know how much time she spent on that, but she made an initial complaint, and then it was handed over for investigation.
And that time that she spent was time working, right?
Objection, asked and answered.
Well, again, I don't know how much time she spent. I don't know if she sent an email, if she had a meeting. I don't know, because I didn't find out about it until after the fact.
Well, the amount of time is, I think, for the purposes of my question, the amount of time is, it's not relevant. I mean, it's whatever the amount of time was, 10 minutes, 30 minutes, an hour, whatever. I mean, are you saying that was not time spent working? Is that what you're saying?
Objection, asked and answered.
I am not saying that. What I'm saying is I have no idea how much time she spent on this, initially making the complaint.
I'm not asking how much time. I'm saying with respect to whatever amount of time it was it work time or not work time? That's the. I mean,
she's answered that question.
She's actually answered it in contradictory ways at this point. First, she said no, and then she said.
I would like to answer
yes,
the question
please.
as best as I can. Because I don't know what she actually did in regards to this complaint, I can't assess if it was actual work or personal work that she was doing. I don't know.
Work or personal work? Okay, and what do you mean by that?
Objection.
Again, what I mean by that is I assume that she made the complaint, it was handed over to be handled properly, and my assumption is that she would move on to other work And again, how she spent her time, I do not know to assess whether or not it was appropriately work time or personal time. I don't know.
Okay. Daniel Slabaugh visited the offices of several Democratic women, right?
Objection.
I don't know.
Okay. I have another exhibit. And this can go to the witness. Thank you. So that's number 2. You take a moment and review the exhibit number 2.
I assume this is not a document that's produced in this case, or?
I'm pretty sure I did produce that in this case, actually.
Okay.
Yeah.
Okay.
Do you recognize exhibit number 2?
Yes, I do.
Can you please describe it?
I believe this is the initial EOCC complaint made by Mrs. Cherry.
Yeah. So just to be clear, copy of a charge of discrimination dated the 5th of March 2024 by Sarah Cherry, filed with. I thought it was with the U.S. Equal Employment Opportunity Commission, although it does say Ohio Civil Rights Commission at the top there, but I do believe it is the U.S. EEOC. Is that correct?
I don't know if that is correct. I believe as an employee of Ohio, it has to go through the Ohio office first.
Okay.
Or
Well,
that is the filing.
leaving aside which agency it was, it's the document is titled Charge of Discrimination. It's dated the 5th of March 2024, and it's by Sarah Cherry. Is that correct?
I understand this to be Sarah Cherry's initial OECC complaint.
Okay. When did you learn of Sarah Cherry's EEOC charge? And to be clear, I mean this document.
I learned...
Continuing objection to all of this line of questioning. I don't want to object
Okay.
to every question. Go ahead.
Well, it appears she filed it March 5th, 2024, so I don't recall exactly, but I assume I learned of it shortly thereafter.
Would that be within a week, would you say?
I don't recall.
Do you think it would have been within 2 weeks?
Objection.
Again, I don't recall exactly, but I would assume within a month.
Within a month, okay.
Yeah.
What did you do when you learned that Sarah Cherry accused Jordan Plodner of pushing her up against a wall?
Objection.
Well, it was the first I had heard of this allegation. I asked Mr. Plotner if it was true. He said no. And then I asked our legal counsel if she would...
Again, don't reveal
Yeah.
what you discussed with
Okay.
legal counsel, so
Thank you.
don't answer the question. Don't repeat. I mean, answer the question without talking about
Yes, and then I spoke with our legal counsel at the time.
Okay. Anything else?
No.
Okay. Did you do an investigation?
Objection.
Again, I spoke with our legal counsel, and I personally did not investigate. I spoke with our legal counsel about the allegation.
Did anyone do an investigation?
I mean, to the extent that you can answer the question without revealing attorney-client privilege.
Well, I'm unclear
Doesn't paragraph 18 address?
No,
I mean-
not this
Oh.
legal counsel.
Oh, I see, okay.
There's no, yeah, I mean, there's no, the question is not directed to anything privileged to the extent that,
So my understanding is that our legal counsel spoke to several staff members who may have been or should have been present at the retreat where the allegation was made.
So if you're repeating what legal counsel told you, then you should not testify
Okay.
to that. So if you are able to answer the question without revealing what
No.
would be discussed, and say your information comes
Well,
from legal counsel.
Yeah, my
Just so we-
information came from it.
just so we understand, privilege does not touch communications just because they're with a lawyer. That's not how that works at all, right? It has to be in connection with legal advice, okay? And as you and I are actually actively in a discovery dispute, there is, some disagreement about, and I would actually say I think the case law is pretty clear, okay, that workplace investigations are not attorney-client privileged, okay?
Okay, well, we can argue about that. I'm instructed her not to answer any questions that would reveal her communications with legal counsel. Now, she can answer the question if she knows independent of her communications with legal counsel.
Well, I will say that, for the record, workplace investigations are not attorney-client privileged, and it should not prevent her from answering any questions to that effect. And if we need to have a conversation, I mean, honestly, this
If
is
you
actually
have knowledge of what happened, you can testify to it. I just don't want
Yeah.
you to discuss the privilege of
Sure.
anything that would be
Sure.
privileged.
I have no direct knowledge of what happened.
you don't know if there was any investigation.
I turned this over to our legal counsel, and again, I have no direct knowledge. And nothing was revealed to me that would suggest that anyone had direct knowledge of this.
Why? So it's based on what you're saying just now, it sounds to me like, to the extent that there was any investigation into this allegation, you did not participate in performing the investigation. Is that fair to say?
I did not participate in performing the investigation.
Yeah. Why not?
Because that is not my responsibility. Again, this was an allegation that was more than 2 years old. And so I asked our legal counsel, I turned it over to her.
Did you ask others if Jordan had ever treated them that way?
Objection.
Again, I referred this to our legal counsel, and I have no direct knowledge that Jordan ever was physical with anyone.
Did anyone ever tell you that Jordan had touched them inappropriately?
I have never been told that Jordan touched someone inappropriately.
Why did Jordan leave employment at the house?
Jordan
Objection.
Plattner left employment because he got offered another position that was higher pay and less stress.
Did you fire Jordan?
I did not.
Objection.
I did not fire Jordan Plattner.
Do you believe that Jordan Plattner pushed Sarah Cherry up against a wall?
Objection.
I do not believe that Jordan Plattner pushed Sarah Cherry up against a wall.
Why not?
Again, because I do not have any direct evidence or corroboration that that ever occurred.
So I want to.
Of what?
Oh.
Do not have any what?
Direct evidence or corroboration that that ever occurred.
I'm going to introduce another. Here. So that'll be number 3, I believe. Here you go.
administrator can look at these.
Oh, sorry.
I'm going to take a moment to review exhibit number 3.
Sure. Okay.
Do you recognize exhibit number 3?
Yes, I do recognize.
Can you please just describe it?
This was documentation of the pattern of behavior of former legal counsel Sarah Cherry.
Why was this document not produced to me in discovery in this proceeding?
Objection.
I don't know.
Who wrote this document?
I can only say who I assume documented was our former chief of staff, Jordan Lautner.
On what day was it written?
Objection.
Well, according to the date at the top of the document, July 26, 2023.
This document describes alleged conduct by Sarah Cherry, right?
Objection.
I would not call this alleged conduct. It documented her work performance leading up to her leaving the Ohio House of Representatives.
But you never gave a copy of this document to Sarah Cherry, right?
Objection.
Again, I'm not responsible for giving documents directly, so I did not give her a copy of this. That is correct.
Did anybody else give her a copy of it?
Objection.
I don't know.
Why was this document created?
Objection.
Well, because there were problems with Mrs. Cherry's work performance, and documentation was made of that problematic work performance.
When a reporter, Jeremy Pelzer, requested records about Sarah Cherry, why was this memorandum or this document not produced to him?
I don't know. You would have to talk to the House Legal Counsel.
This document existed at the time of a Jeremy Pelzer public records request in January 2025, right?
Objection.
It did exist at that time. Again, I don't know why it was not produced.
To whom have you given this document?
Objection.
To whom have I given this document? I don't know.
Can you tell me anybody and the name of any person to whom you've given this document?
Objection.
So to be clear, this document is now a public record because it has been requested and provided, to my knowledge, to at least a couple of reporters.
Can you tell me their names?
I cannot, because I do not directly handle public records requests.
Is there anybody other than those couple of reporters you just referred to whom who would have obtained a copy of this document? Yeah.
Sure. In the last 2 weeks, I became aware that Ms. Cherry, in a series of public posts in interviews, has been making what I think are incorrect accusations. And someone asked for the information, and so I provided them with her original complaint, I believe, the disciplinary report from Perez Morris, and I believe we had a copy of this as well.
Did Sarah lie about you?
Objection.
Yes, I believe she has lied and is lying about me, yes.
In what respect?
Objection.
Well, in multiple ways.
Can you name one or more?
She is alleging that her departure from the Ohio House is not about her work performance, and that is incorrect. That is a lie.
In what respect is it a lie?
Objection.
In that she was terminated for poor and inconsistent work performance, as documented in this memo.
The contents of this memo are true and accurate, right?
Objection.
To the best of my knowledge, I believe them to be accurate.
Are there any parts of it that you question the truth or accuracy?
Objection.
I have no reason to believe that there are portions of this memo that are not truthful.
The memo references, quote, unfavorable findings of an outside counsel report, 5/21/23, unquote, right? It's on the first. It's on the first. It's at the top of the first page.
Okay.
In the first bullet. It says following the unfavorable findings of an outside counsel report, 5/21/23. Do you see that?
Yes. What is your question? Sorry.
Can you
restate your question?
Just confirming that indeed that language does appear in the document. That's all.
The language says following the unfavorable findings of an outside counsel report and the House Speaker's decision to follow the House Public Records retention schedule for letters of discipline in Sarah's personnel file, Sarah has been clocking in intermittently but not attending to business meetings or requests and directives of the leader. And then it goes on to specifically outline when those occurred.
Right. Okay, so I just want to focus on the date in that first parenthetical in the beginning of that sentence that you just read. The report done by Perez Morris, investigating the complaint made by Sarah Cherry, making allegations against Kim Ziano Hartman. The date of that report is the 31st, not the 21st of May, 2023. Isn't that correct?
Objection.
Again, I don't recall the date, but it is possible that there's a typo in the date.
Okay. When did you receive a copy of the Perez Morris Ziano report?
I don't recall the exact, actually I may have it documented here. Hold on. Actually, I don't recall immediately when I received the report, but I assumed that it was shortly after it was made available.
Would June 7th or June 8th, 2023, would that, be a reasonable guess as to when you might have received it?
Objection.
I don't recall.
Okay. Well, you said, I think you just said shortly after it was made available. If indeed the date of the report was the 31st of May, 2023, then are we talking like 1 week, 2 weeks, a month? Can you give me any sort of sense about that?
Objection.
Again, I don't recall specifically when it was made available to us because it was a report that had been commissioned by the majority. I can only assume that they gave it to us within the next week, but I don't recall exactly.
Okay. This document says that Sarah Cherry clocked in, quote unquote, intermittently. What does that mean?
Objection.
Well, it meant that she was not consistently clocking in during normal work hours or for normal work periods of time.
This document says that Sarah was not attending to, quote unquote, requests and directives of the leader. Isn't that right?
Where does it say that?
I think it's in the portion that you read.
Oh, yes, it does say that.
Yeah. You didn't make, after the 9th of June 2023, for the rest of the month of June 2023, you didn't make any requests of Sarah Cherry. Isn't that right?
Objection.
No, I do not believe that is correct.
How is that not correct?
Well, Sarah Cherry was our chief legal counsel. She was the second most important employee of the caucus and senior. That is not correct, that she would not have been asked to perform her work duties for a solid month. On
what day did you make a request?
Objection.
I don't recall specific days, but the assumption is that every day there are duties of the chief legal counsel.
What was the request?
Objection.
Again, if you were asking me to enumerate specific requests, I don't recall those, but there's always work to be done by a chief legal counsel.
How did you make the request? Did you speak to her in person, on the phone? Did you message her? Did you email her?
Objection.
Again, the chief legal counsel of the caucus is a key employee who is in and out of the minority leader's office quite often.
I don't hear an answer to my question.
She answered your question, I don't recall. So you can ask it again if you want, but rating her saying you don't hear an answer to the question is not appropriate. So you can ask a question and then she can answer it.
It sounds to me like you are saying that she was supposed to read your mind. Is that correct?
Objection.
I disagree with your characterization of that. The expectation is that the chief legal counsel is an integral part of a leadership team, and there is always work to be done by the chief legal counsel, especially in the month of June when we are in budget season and getting ready to pass a budget at the end of the month.
And how was she supposed to know what you wanted her to do?
Objection.
Again, a chief legal counsel does not need hand-holding to do her job.
Jordan did not give Sarah any directives or requests on your behalf after the 9th of June 2023 for the rest of that month. Isn't that correct?
Objection.
I do not know that to be true.
How did he make his request?
Objection.
Again, chief legal counsel is an integral part of the team. There is always work to be done, especially in June of an odd year.
Sounds like you're saying that she was supposed to read both of your minds. Is that correct?
Objection.
That is not correct. That is not what I said.
What were Jordan's requests?
Objection. Asked and answered.
Again, I do not recall because this was over 2 years ago.
No general. You said budget. Was there a budget-related request to your memory?
Objection.
Again, I do not recall specifics, but there are hundreds of things within a budget that all of our senior staff are responding to. to prepare members for votes.
Okay, so of those hundreds of things, were there one or more that were assigned to Sarah?
Objection.
Again, as the chief legal counsel of the caucus, there are always multiple tasks and things to be done, especially as it relates to the budget.
Sounds to me like you didn't name one of the hundreds of things. I didn't hear you identify one. Can you identify one?
Elliot, she's asked the question 3 times, so you can answer it again, but she says she does not recall specific requests, but go ahead.
I do not recall specific requests. I can only assume that there were certainly things related to elections. There were probably provisions that related to civil and criminal justice that we would have asked or wanted the chief legal counsel to weigh in on, as is normal during any budget.
Did you ask her to weigh in on those things?
Objection.
Again, my assumption is that she was asked to weigh in on several things, not just by me. I will remind you that she was the chief legal counsel of the entire caucus. And there are multiple caucus members and staff members who rely on her to provide advice and counsel.
Yeah, and Ms. Russo.
Representative Russo, or Dr. Russo, you pick.
I'm familiar with the things that you're describing because I was also a member of this caucus. And in fact, I worked with the chief legal counsel of the caucus, right? I never assumed that she was going to do anything specific for me if I didn't ask her to do it. So I don't entirely understand your answers here, in which you say that there was just a standing assumption that she was going to act on behalf of various members of the caucus when they hadn't made any specific request. I apologize, but I remain confused about all of the answers you've given to all of the questions in this line.
You can ask questions. You're giving an argument. You're berating the witness. I object to that. You can ask a question, but you cannot just argue with the witness and berate her because you don't like the answer that she gave. So if you have a question to ask, please ask it. And saying I'm confused doesn't going to change her answer. She's going to have the same answer to your questions.
You did not speak to Sarah Cherry or contact her between the 10th of June and the 10th of July 2023. Isn't that right?
I don't recall that that is true.
Can you describe any contacts that you did have with her during that period?
Again, this was over 2 years ago. I don't recall specific interactions with her, but this is the Ohio House of Representatives in the busiest time during the General Assembly. I feel certain we saw and talked to each other during that time.
Can you, identify and describe one of those times?
At this moment, I cannot specifically recall. Again, this was 2.5 years ago.
Jordan Plotner did not speak to Ms. Cherry or message her or return her calls or messages between the 13th of June and the 7th of July 2023. Isn't that right?
Objection.
I do not know if that is true or not.
Are you aware of any contacts during that period that Plotner had with Sarah Cherry?
Objection.
I do not have any direct knowledge, one way or the other, to be able to assess the truthfulness of that.
The memo states, or the document, it states, Friday, June 2nd, this is the first sub-bullet. Friday, June 2nd, absent 3.37 hours with no notice, not scheduled off. Do you see that?
Yes.
What does that mean?
Okay, I'm going to object to that. Let's take a break because this is getting far afield. She is not, I prepared her to answer your questions. I did not prepare her to answer questions about a completely different case that I know nothing about. And so this is getting really far afield.
This document is in the possession of your client, and you know, the fact that you didn't produce it to me is actually a demonstration of violation of the duties to discovery. I mean, why didn't you give it to me, Steve?
Because it's not relevant to this case, and this is showing your deposition is showing Exhibit A as to how, and you've already spent an hour and 20 minutes on this topic, and so I just would like you to move on to the subject matter of this case. We are not prepared to testify about.
We're off the record.
No, we're on the record. I'm not prepared. She's not prepared to testify about these questions. Now, I'm going to lie. I've allowed you to continue for an hour and 20 minutes.
No, let's get this straight. You don't allow me to do anything. The rules allow me to do what I'm doing. The rules, not you.
You want to raise your voice with me again?
If you keep violating the rules, then yeah.
You're going to intimidate me into backing off? Is that what you're going to do?
To trying to comply with the rules? I mean, I would love it. I would love it if you follow the rules without any of this.
What? Okay. Let's just take a 5-minute break and we'll be right back. So if you can go back.
I restarted my my audio.
Yeah, thanks.
You ready? Okay. So we're still on Exhibit 3. The document states in that first sub-bullet, Friday, June 2nd, absent 3.37 hours with no notice, not scheduled off. What does that mean?
Objection.
Well, I did not write this memo, so I only know what is written here. Stated the hours that she was absent and not scheduled off. I have no reason to believe it's not true.
Didn't Sarah Cherry, in fact, email you that day, June 2nd, that she was upset about the investigation into her complaint taking so long?
I don't know.
And didn't her email say that harassment of women was ongoing?
Again, I don't know.
Did you respond to Sarah's email?
I don't recall.
You have no memory?
I have no memory.
Okay. So you're saying, yeah, that with respect to an email from your caucus legal counsel raising concerns about harassment of women in the workplace, you don't remember whether or not you responded. Is that correct?
Objection.
I don't recall the email. I don't know if I responded or not. To be frank with you, I'm not even sure if I saw the email. I don't recall.
Sarah Cherry called and spoke to Jordan Plotner on the 2nd of June, 2023, and let him know that she was leaving work early for an appointment. Isn't that right?
Objection.
I have no direct knowledge of that. I don't know.
Sarah Cherry recorded her start and end times that day in accordance with House procedures. Isn't that right?
Objection.
I don't know.
What was the procedure in 2023 for your...
If you could slow down.
Sorry. What was the procedure in 2023 for your senior staff to use and record their time?
Well, I generally ask people to just let us know if they were going to be out of the office. I trusted people are adults and using their time off, but they had to certainly follow the rules by the laid out by House administration about how to record their time.
Where was this procedure documented?
Which procedure are you referring to?
What you just described.
Well, the procedure for documenting time by the House administration is in the personnel handbook, guidebook, whatever it's called.
And then with respect to...
I'm sorry.
And then with respect to the, because you said that in addition to the House administration, that you, I think you said, what was it that you just assumed that people are adults with respect to using their time? Is that what you were saying essentially?
Objection. She said what she said.
My question is, is that procedure documented anywhere?
Again, every employee of the House Democratic Caucus is expected to follow documenting their time in the way that was outlined by House administration. That was an expectation, yes.
Okay. Sarah Cherry wrote in 2022 a memo describing Democratic Caucus staff time procedures, right?
Objection.
I don't know. I don't know what memo you're referring to.
Did your chief of staff ever document Democratic Caucus staff time procedures?
Objection.
I don't know.
What were the Democratic Caucus staff time procedures?
Objection.
I don't know. I, again, believe that they followed the House administration procedures for documenting time.
Caucus staff worked into the evening sometimes, isn't that right?
Objection.
It is correct that staff work beyond normal work hours, especially when we are in session.
Caucus staff sometimes came in later because they would be working late, isn't that right?
Objection.
It is correct that some people certainly work late and adjust their hours in the morning. However, there were procedures, especially for our legislative aides, about how flexible that start and stop time the start time can be.
Caucus staff sometimes used their leave to do political volunteer work, isn't that right?
Objection.
Yes, there are staff who will take leave to do political work, sure.
Senior staff frequently worked irregular hours depending on legislative schedules, isn't that right?
Objection.
It would not be abnormal to work irregular hours, meaning start and stop times, certainly not shorting your hours, even during busy periods of time.
You never asked Kim Hartman Ziano to discipline your staff, isn't that right?
Objection.
I don't recall asking her to discipline staff.
So are you saying it's possible that you did ask her to discipline staff?
Objection.
I don't recall ever asking her to discipline staff.
Sarah Cherry was never investigated by outside counsel for any conduct, isn't that right?
Objection.
I don't believe that is correct.
When was she investigated by outside counsel?
Well, I believe before I became minority leader, there was some outside counsel report that related to Mrs. Cherry. And certainly in the outside counsel report that was generated by Perez Morris, there was documentation of, I think, some actions by Mrs. Cherry. That's my recollection.
So you're saying that an outside counsel report that was supposed to be investigating a complaint made by Sarah Cherry was actually investigating Sarah Cherry?
Objection. Mischaracterized your testimony.
I am not saying that. I'm saying as part of the report, there was an investigation of Mrs. Cherry's, whether or not disciplinary files should or should not be deleted. And as a result of that, there was information about disciplinary actions.
You made reference just a moment ago to, I think what you were saying was there was an outside counsel report from before you were minority leader that was investigating Sarah Cherry. Is that correct?
I don't know if that is correct. I am aware of a report and an outside investigation before I became minority leader. I do not know the details of that, but I do know that it involved also Ms. Cherry.
Do you know anything about the conduct that was investigated in that report?
I don't recall. I would have to look at the report again. It's been a long time since I've seen it.
Do you know who made the complaint in that case?
I do not.
The document here says, quote, and this is just the second bullet point, Thursday, June 8th, absent 4.44 hours with no notice, not scheduled off, unquote. Do you see that?
Yes.
What does that mean?
Absent 4.4 hours with no notice, not scheduled off. I'm reading what the report said.
So, what does it mean?
It means what is written.
Does it mean that Sarah Cherry was absent on that day, 4.44 hours with no notice, and that she was not scheduled to be off during that period, during that time that she was absent? Is that what it means?
Objection.
As reading the report, that is, it says she was absent 4.44 hours with no notice, not scheduled off.
Did Sarah Cherry attend on that day, the 8th of June, 2023, a baseball game with other director-level staff during the afternoon?
I don't know.
Those other directors were men. Isn't that right? Andy DePalma, Nick Muccio, Steve Harris?
Objection.
I don't know.
No document like this, documenting that Sarah Cherry's male colleagues were absent without notice on June 8th or not scheduled to be off, exists. Isn't that right?
Objection.
I am not aware of a document, but also I'm not aware whether or not they requested time off.
Did you ever tell the people with whom you shared this document that you don't know if the things in this document are true?
Objection.
I'm sorry, repeat your question?
You said before in this deposition that you shared this document with a couple of reporters, some other people.
That is actually not what I said. I did not say that I shared it with reporters.
We can have him read it back.
Please.
Would you mind, please?
She's never going to be able to find that
Yeah, I don't have a way to.
unless it's something.
Okay. Then I'll just ask it again. So to whom did you give this document?
Specifically, this document, recently there was a blogger who Sarah Cherry had made accusations against me, and he asked me about it, and so I provided what was public records, and it included this document.
What's the name of the blogger?
His name is Matthew Deemer.
He's a former congressional candidate?
I believe that is correct.
Yeah.
I don't know him well.
Yeah.
But he now has a blog and a podcast.
Good for him. Did you ever tell Matthew Deemer that you don't know if the things in this document are true?
Objection. She's never said that she doesn't know the things in this document.
I have no reason to believe that the things in this document are untrue.
Okay, so just to be clear, it sounds like what you're saying is that you did not tell Matthew Deemer that you don't know if there are any things in this document that are not true. Is that correct?
I had no discussion with Mr. Deemer about the contents of this document.
Okay. So, Matthew Deemer and anybody else with whom you would have shared this document, I mean, they would have thought that, he and anybody else would have thought that you were offering it as true. Isn't that right?
Objection.
I don't know what Mr. Deemer thought.
Can you just remind me, why did you gave it to Matthew Deemer? Tell me again, why did you give it to him?
Objection.
He had reached out, apparently Mrs. Cherry had reached out to him, and he reached out to me for a response. And I simply provided him with documentation that was public record, gave him a link to a Cleveland.com article, and that was it. I left it to him.
Do you know if Sarah Cherry disputes the content of this document?
Objection.
I don't know.
Did you tell anyone with whom you shared this document that Sarah Cherry disputes any of its contents or might dispute any of its contents?
Objection.
I have not had that discussion with anyone.
The memo says on the third sub-bullet, quote, Friday, June 9th, absent 2.22 hours with no notice, not scheduled off. Do you see that?
Yes.
All right. I need to show you another. Okay, hold on. Oh, shoot. Sorry, one moment. Hang on one moment. might have misplaced this.
While you're doing that, let me just continue to object to this being a deposition about Sarah Cherry's claim rather than your claim. I think it's inappropriate. Go ahead.
I'm just making sure. Do I have this? Hang on one moment.
Okay, yes, no, I do have it. Okay. So this will be number 4.
You can just lay it down.
Okay, thank you.
Let me just say Exhibit 4 looks like a document created by
Well,
Sarah
I'm not on the
Cherry.
record. If you're putting something on the record, take that.
You can take a moment to review exhibit number 4.
If you wanted to put something on in.
She said you could put something on the record.
If you're, I was marking the exhibit.
Oh, I just said, I object to this exhibit. This looks like a demonstrative exhibit put together by Sarah Cherry, relating to her claim, not Mr. Forhan's claim. Go ahead.
Do you recognize anything about exhibit number 4?
This appears to be a birthday happy hour for Jordan Plotner that would have occurred after work hours.
So just to be clear, this is a well, it has some markings, but it's the underlying part of this exhibit. It's a photograph of you, Sarah Cherry, and Jordan Plotner, and other people at a birthday happy hour for Jordan. Is that right?
This was a birthday happy hour for Jordan Plotner, again after work hours.
So the time of the taking of the photograph, the image, was within the 4 p.m. to 6 p.m. Range. Is that correct?
I don't know if that is correct.
Deputy Chief of Staff Andy DePalma is present. Isn't that correct?
I don't know. Is that him covered by an arrow? Can't see the face. I don't know if that's Andy.
Chief of Staff Jordan Plotner is there, right?
Yes, Jordan Plotner is here. Yes.
And Policy Director Nick Muccio is there, right?
Yes.
And Budget Director, go ahead.
Yes.
Budget Director Steve Harris is there, right?
Yes.
Communications Director David Myers is there, right?
Yes.
And all those people are all men, right?
The ones that you named, but there are other females in this picture as well.
Sorry, go ahead.
Yes, there are 1, 2, 3 other female staffers in this picture.
There is no memo like exhibit number 3 about any of the male director level staff members about being absent without notice while they're at this happy hour, right?
Objection. It seems facts that are not in evidence. Go ahead.
am not aware, but also not aware that they didn't work a full day or request time off. Same for the female staff members.
You asked the staff to attend this happy hour, didn't you?
I don't recall. I'm sure there was an open invite to all of our caucus staff, as well as some members.
Who initiated this happy hour?
I don't recall.
Objection.
You expected the staff to attend, isn't that right?
Objection.
No, a happy hour like this after work hours is not expected. Everyone is invited. They choose if they come or not.
Did you think that they would want to attend?
Objection.
Again, they choose if they want to come or not. This is an after hours work event.
An
after work hours event.
Isn't it true that you thought that they would want to attend because they had a friendly relationship with one another?
I don't make any assumptions about who chooses or doesn't choose an after-work event or why they choose it. We were celebrating a colleague's birthday.
Did you have friendly relationships with these staff members?
Objection.
I don't see a single staff member in this picture that I would not have had a good working relationship with.
Is that the same? Is a good working relationship the same as a friendly relationship? Just to be clear.
Objection.
No, not necessarily. I was the House Minority Leader. These are staff members. I have a professional working relationship, and I care about our staff members. Are we friends? I wouldn't call it friends. It's a working relationship.
So you'd say you're not friends with any of those people?
No, that's not what I said. I said that I was the House Minority Leader. These are people who worked under my supervision, all of them.
So are you saying that in a situation like that, it's not possible to have a friendly relationship with somebody? Is that what I'm trying to understand?
She's answered the question.
She has not answered the question.
She has. You're asking her to say it differently. She answered the question. She's saying what she's saying. You're asking her, are you saying something different? She's saying what she's saying. Go ahead.
She didn't answer the question, Steve.
She did.
You are.
You could ask the question again, and she'll answer it again.
This was
Please stop ruining my deposition.
I'm not ruining your deposition. I'm objecting when you ask the same question 4 times. Go ahead. You can ask it again if you want.
Again, this was a casual after work hours event of individuals who worked for the House caucus. I was the House Minority Leader. I believe they all had a good time.
Is it possible to have a friendly relationship with a member of the staff when you're the House Minority Caucus Leader?
Sure, it is possible to have a friendly relationship. Does that mean that we are close personal friends? No, again, it's a working relationship.
Okay. You had invited these staff members to this happy hour just the day before, isn't that right?
I don't recall how the invitation went out.
You don't remember when you invited them?
No, I don't.
Why did you include this in the document purporting to document alleged misconduct by Sarah Cherry?
Again, what are you referring to as this?
The Friday, June 9th, absent 2.22 hours with no notice, not scheduled off.
Again, I did not write the memo, so I can't comment on why it was included other than it appears that Ms. Cherry did not work a full workday.
Do you think it makes sense to, include in a document like this, purporting to...
Just so we're clear, you say document like this.
Sorry, I apologize. I'm talking about exhibit number 3.
Right.
Right, thank you. Do you think it's appropriate to include in a document like exhibit number 3, something like, going to a work happy hour?
Again, this was not a work happy hour. This was an after work hours happy hour. That was not part of the normal work day. It was after hours. Do I think that it is, what term did you use, appropriate? Is that what you said?
Yes.
If Mrs. Cherry did not work a full work day and gave no notice of time off, yes, that's appropriate. But again, a work day does not include an after hours event.
Back to exhibit number 3. This file was named and saved as SC documentation of resignation in lieu of termination. Isn't that right?
I don't know how it was saved.
You were aware that Sarah Cherry did voter protection for the Democratic Party, right?
Yes, I'm aware that she did that.
And Sarah had done off-the-clock voter protection political volunteering that morning of the 9th of June, the same day. Isn't that right?
I
Objection.
actually don't know if that is true or not. I have no evidence or documentation of that.
Sarah Cherry did voter protection for your congressional race when you ran in 2021. Isn't that right?
Actually, I don't know.
The Exhibit 3, it says, quote, and this is in the 4th sub-bullet point, Monday, June 12, Sarah was scheduled out of office but responded to 2 House members that she was out of commission for a while, implying she would not assist with their inquiries or tasks indefinitely, unquote. Is that accurate?
That is what this document says.
Yeah. In fact, the email from Sarah Cherry says out of commission for a time, not a while. Isn't that right?
Which email are you referring to?
Where I was just reading in the memo,
Yes, but what email?
Exhibit 3. Exhibit 3.
Which email?
No. So on the first page of Exhibit 3.
Yes, I see what you're saying, but
Right.
you reference an email. You say, in fact, she said something in an email. Which email?
The email is not. I'm asking from your memory.
I don't recall.
Okay.
I don't recall an email. I don't know.
Yeah. In fact, Sarah Cherry said that she hoped that it could be resolved soon. Isn't that right?
Again, I don't know which email you're referring to.
Sarah Cherry had just been given a long report about her workplace complaint just five days earlier. Isn't that right?
I don't recall the specific date that she got her report, or the report related to her complaint.
And on the 12th of June, the Speaker of the House had not made a decision yet on what to do about the matter. Isn't that right?
Objection.
Again, what to do about what matter? What are you?
The matter that
referring
was
to?
investigated by Perez Morris and set forth in the Ziano matter.
Objection.
I'm not sure there was a decision to be made about the matter. The report was the report.
Well, I mean, but Perez Morris has no power to tell the Speaker what to do, right?
Objection.
Again, I don't know what. I'm not clear what matter you're referring to that the Speaker was supposed to be making a decision about.
About whether or not to, for example, whether or not to delete the discipline reports in Sarah Cherry's personnel file.
Objection.
So is that what you're asking? Is if a decision? Please restate your question so I know what you're talking about.
On the 12th of June, the date that's in this 4th sub-bullet point, the Speaker of the House had not yet made a decision on what to do about that issue, right?
I don't know if he had made a decision, if you were referring to deleting of the files, but he had not communicated that to me.
Okay. It was Sarah Cherry's job to analyze the report, the Perez Morris Ziano report, and make a recommendation of next steps. Isn't that right?
Objection. I think you're misstating. You said Sarah Cherry.
It was Sarah Cherry's job to analyze the report, the Perez Morris Ziano report,
Okay.
and make a recommendation of next
Okay.
steps.
Sorry.
It's okay.
I don't necessarily agree that that was her job.
Why do you disagree?
I don't agree that that was her job to analyze a report. That I don't agree with that.
Was it, just commonplace that that the House Democratic Caucus under your leadership would just go along with whatever the Republicans thought they were going to do?
Objection.
No, that is not correct, but it was not. She had not been asked to analyze this report or spend additional time on it. I assume she wanted to read it and analyze it, but there was other work to be done for the caucus.
So it wasn't within the duties of the chief legal counsel of the Ohio House Democratic Caucus to review and determine next steps with respect to a report like that.
She could certainly, I assume that she reviewed it and would consider next steps, but it personally involved her, and spending hours upon hours of time on it in lieu of other work of the caucus. I don't agree that was her primary responsibility.
If the report had something to do with a member, or let's say with respect to a member of the leadership team of the Ohio House Democratic Caucus, or with respect to the leader herself of the Ohio House Democratic Caucus, would it have been part of the job of the chief legal counsel of the Ohio House Democratic Caucus to review the report and make a recommendation of next steps?
Objection.
You're asking me a hypothetical question for something that did not exist. There are many responsibilities of a chief legal counsel. Spending hours upon hours of time on this report and reviewing it was not a primary responsibility.
Again, if the report had been about somebody else, let's say, I don't know, about Rachel Baker, or about Cindy Peters, or about Dontavius Gerald, or about Terrence Upchurch, right? Any of them. Would it have been the job of the chief legal counsel to review the report and make a recommendation of next steps?
Objection.
Well, again, the report was not about any of those individuals, and I can't assess how much time should or should not be spent by the legal counsel on a circumstance that didn't exist.
You have no opinion?
I have no...
Okay.
I
All right.
can't answer
We'll move
your
on.
question.
All right. In fact, there is nothing in... actually, hold on. Just wait one moment. Oh, actually, okay. I apologize. There is a copy of this email. Sorry. This is on page 1, 2, 3, 4... 1, 2, 3, 4, 5, 6. Yeah. Yeah. There it is. Okay, so here's the question. There is nothing in this email being the email that appears at the bottom of the 6th page of
The email dated...
Exhibit 3, dated the 12th of June, 2023.
At what time?
The one at the bottom. This.
Oh, I see. Okay.
No, that's not it. He's asking about the second to last page. What?
On the 6th page.
The Monday, June 12th at 9:23 a.m. email?
Yes.
Oh, no. Oh, you are seeing another one. Okay, sorry.
Oh, wait, but those are, sorry.
Which email are you asking? I'm sorry.
Okay.
There are
This
multiple
is-
emails here.
Okay, sorry. So let's back up here.
Just
Let's
give the
back
date
up.
and time of the email, that's all.
All right. So do you have the pages in order of the exhibit? Can you flip to the 1, 2, 3,
Oh, I see. It's at the bottom of the page.
4, 5, 6. So the body of the email on the 6th page of the exhibit, the body of the document ends, and there's a header. It says Sarah's communication to members refusing to contribute to work. Do you see that header?
Mm-hmm.
Yeah. And then immediately below the header, there's an email that it starts there and it continues onto the subsequent page. Do you see that?
Yes.
Yeah. Okay. So with respect to this email, my question is the following. And by the way, this email is dated the 12th of June, 2023. It's from Sarah Cherry, and it's, the recipients are redacted other than there's a carbon copy for Michelle Grimm. Is that correct?
Yes.
Okay. So, in fact, there is nothing in this email that indicates that Sarah Cherry would not assist the member indefinitely. Isn't that correct?
Objection.
I read this as I am out of commission for a time as I deal with a serious administrative matter affecting my employment status at the House. I hope it can be resolved soon so I can return to being a productive resource for the caucus. I read that as she didn't give a time, nor did she give resolution to the member's request.
Isn't it true that Sarah Cherry in this email expressed the opposite sentiment, that it would be resolved soon so that she could help them?
Objection.
I'm sorry, what could be resolved soon? The issue the member's asking her about, or
The
her
serious,
own personal issue?
the serious administrative matter.
So what is your question?
Isn't it true that this email expresses that Sarah hoped that the administrative matter would be resolved soon so that she could help the member?
Objection.
She actually doesn't say so she can help the member. So no, that's not true. She says so that she can return to being a productive resource for the caucus. She does not give further direction to the member.
Okay. You did not call or text or email Sarah Cherry about this email. Isn't that correct?
I don't know. I don't recall.
In fact, Ms. Cherry sent this email to Jordan Plotner and other colleagues to let him know how she was managing her time. Isn't that correct?
Again, I don't know. It's redacted. I have no idea.
Ms. Cherry served the caucus of 32 or more members and a staff of more than 50 people. Isn't that correct?
I believe that sounds like certainly the number of members, total staff. That sounds correct.
Sarah Cherry would routinely have to prioritize tasks and manage expectations and schedules. Isn't that correct?
Objection.
All staff members have to do that.
Your staff would sometimes, is there something, Steve?
I just want to state for the record that we're now at 3:05. We've not had a single question about this case. It's all been about Sarah Cherry. In fact, I believe that Sarah Cherry is the one who wrote these questions for Mr. Forhan to use this deposition as a vehicle to gain discovery for aiding of her claim. And so I would allow
Should I be calling the attorney that is working this case?
I mean, that's up to you, but I'm hoping that you're wrapping up soon because there's only limited time available here today. So just go ahead and...
I would like to note that I have no legal representation for Mrs. Cherry's complaint for the Ohio House of Representatives is not present in this deposition.
Any other notes for the record? Anybody need a break?
No, keep going.
You want to take a break? Okay, we'll take a break. I'm ready whenever you are.
As far as timing, do you expect this to go after 5 o'clock?
How late can you go?
5 o'clock.
That's a hard stop.
It wasn't scheduled to go past, so
Five.
that's what I'm asking. It wasn't.
Okay. Yeah. When I talked to Veritex, we didn't discuss a stopping time.
Yeah, but they would note if it was going past
Okay.
business hours. That's what I was asking.
Okay.
So
All
why
right.
don't you get to the subject matter here so we can get it done.
Steve, please come on. All right. So
I mean,
so the 5 o'clock is a hard stop for you. Is that right?
I mean, or I can go a little after that.
Okay.
But I'm not.
Okay. Well, I would appreciate it, as far as we can go. So, are you ready?
Mm-hmm.
All right. Your staff would sometimes have to direct members to the correct resource to assist them. Isn't that right?
Part of the staff's job is to assist members in whatever their needs are. Certainly directing them to resources would be part of that.
I couldn't hear you.
I said certainly directing them to resources would be part of that assistance.
The document says that Sarah Cherry was instructed to set an, quote, out-of-office message directing inquiries to Minority Deputy Legal Counsel, DLC, unquote. Isn't that correct?
I'm sorry, which?
So this is under the fourth, I'm on the first page of Exhibit 3. The fourth sub-bullet that starts Monday, June 12th, there's a sub-bullet. Mm-hmm. You see that?
Mm-hmm.
Okay.
Yes.
Okay. Sarah was not out of the office, right?
Again, I don't recall. I don't know if she was not working normal hours or able to respond to members' requests. Then certainly referring it to the Minority Deputy Legal Counsel would be appropriate.
Would you typically ask a staff member to set an out-of-office message when they were there working?
I typically would not have provided instructions to any of our caucus staff as it relates to how they email our caucus members.
Sarah never told you that she wasn't working, isn't that right?
Objection.
I don't recall Sarah communicating at all about what she was doing during this time.
You never witnessed Sarah not working, isn't that right?
Objection.
I witnessed Sarah not being present multiple times at meetings.
You never went to Sarah's office during this time, isn't that right?
I don't recall if I went to Sarah's office or not. This was 2.5 years ago.
You never called her during that time, right?
I don't recall who I did or did not call 2.5 years ago.
You never texted her?
I don't recall what I did or did not text 2.5 years ago.
Never emailed her?
Objection.
I don't recall what was or was not emailed, although I will say typically I do not email any staff.
Sarah told Jordan Plotner that she would not set an out-of-office message because she was not out of the office. Isn't that correct?
I don't know what Sarah told Jordan Plotner.
The document says, quote, Tuesday, June 13th, it's the next sub-bullet, absent 4.13 hours with no notice, not scheduled off, did not attend weekly leadership meeting, unquote. Isn't that right?
Yes, that is what it says.
In fact, Sarah Cherry called Jordan Plotner that morning to alert him that she would be out for half of a day. Isn't that correct?
Objection.
I don't know. I don't have direct knowledge of that.
Did Sarah Cherry call Jordan Plotner that morning?
Objection.
Again, I'm not Jordan Plotner. I don't know.
That language that I just read references a leadership meeting. In fact, Jordan Plotner had, just the day before, asked Sarah Cherry to set an out-of-office message. Isn't that correct?
Objection.
Again, I don't know. I don't have a copy of the communication that you're referring to.
You didn't call or contact Sarah Cherry about not attending the leadership meeting. Isn't that correct?
I don't recall. This was 2.5 years ago.
Jordan Plotner didn't call or contact Sarah Cherry about attending the leadership meeting. Isn't that right?
I don't know. I'm not Jordan Plotner.
The memo says, quote, Friday, June 16th. Just the next sub-bullet. Absent 3.59 hours with no notice, not scheduled off, unquote. Isn't that right?
That is what it appears to say in this memo.
You were aware that Fridays during an election cycle, there was voter protection volunteer work to do. Isn't that right?
No,
Objection.
I was not aware of that.
And Sarah Cherry recorded her time using the House procedures on this day. Isn't that right?
Objection.
I don't know.
And Sarah Cherry gave a training to the Sherrod Brown campaign on that day. Isn't that right?
Objection.
I don't know.
And Sarah was doing extra voter protection work because her co-leader of voter protection, Bethany Sanders' mother, had just died. Isn't that right?
Again,
Objection.
I don't know.
Did Jordan Plotner not tell you that Bethany Sanders' mother had just died?
Objection.
Bethany Sanders was not an employee of the Ohio House Democratic Caucus on January 16th, 2023.
Did Jordan tell you that Bethany Sanders' brother had also recently died?
Objection.
Again, Bethany
Way off the
Sanders
reservation.
was not an employee of our caucus. I don't recall him saying, nor would he have had a reason to tell me that.
The memo says, quote, Wednesday, June 28th, on the next page. 1 second sub-bullet down from the top. Wednesday, June 28th, absent 2 hours with no notice, not scheduled off on quote. Is that correct?
That is what it says.
In fact, Sarah Cherry worked more than 8 hours that day, ending at 7:50 p.m. Isn't that right?
Objection.
Again, I don't know.
Have you ever written any documents about male staff members, or any male staff member, alleging misconduct and missing 2 hours of work if they worked more than 8 hours in a day?
Objection.
I don't believe I've written any document about any employee about time off or time not worked. I told you again, I did not write this document.
Have any of your subordinates written any memos about male staff alleging misconduct and missing 2 hours of work if they worked more than 8 hours in a day?
I don't know.
Wait till he gives them the question.
Yeah, sure.
Is working from 11:30 a.m. to 7:50 p.m. during a budget month in the legislature misconduct?
Again, I don't know what circumstance you're referring to, nor do I have direct knowledge of whether or not that is correct or not correct.
I'm going to ask the question again. Is working from 8:30 a.m. to 7:50 p.m. during a budget month in the legislature misconduct?
Again, are you referring to a hypothetical or to an actual work hours?
In general.
Again, I'm not going to speak in generalities. I don't know. Did someone record their time? I don't know.
Sure, if they recorded their time.
Again, I don't know because I don't know what the circumstances of your hypothetical are.
If Jordan Plotner worked from 11:30 a.m. to 7:50 p.m. during a budget month in the legislature, would that be misconduct?
Again, I don't know what the circumstances of that would be.
Okay. The memo says, quote, Friday, June 30th. It's the next sub-bullet down. Absent 2.24 hours with no notice, not scheduled off on quote. Is that accurate?
That is what it says, yes.
In fact, Jordan Plotner had notice of Sarah Cherry's work on that day. Isn't that right?
I do not know.
Sarah Cherry had a voter protection meeting and work to do that morning off the clock. Isn't that right?
Again, I don't know. However, I'd like to point out that voter protection work is not caucus or state work.
Your staff don't do political work on the clock. Isn't that right?
Staff should not do political work on the clock.
And Ms. Cherry had attended a funeral for a member's family member in Cleveland the night before with other staff. Isn't that right?
I don't know. I don't know. You'll have to be more specific.
Wasn't
Okay.
that?
I'm being advised that we need to stop any further questions regarding Sarah Cherry's claim. So you can take that up with the judge if you want, but I'm not going to allow for any more questionings because it's a matter of a separate pending case. They have separate representation who are not here to defend the deposition, and that's what I'm being instructed. So
Yeah.
you can move on to another topic, but I'm not going to allow any more questions about Sarah Cherry.
Okay, so here we go. I'm going to read for the third time today.
Hey, Elliot,
Yeah.
you made your point.
Yeah.
You can raise it with the judge, but for today, we're done with the Sarah Cherry questions because that's the instructions I'm receiving from the counsel that's representing the General Assembly with regard to that claim.
Okay.
I don't have any ability to not allow that to happen. To allow it to continue.
All right. Okay.
So you can raise that with the
All
judge.
right. So here we go.
I did
Ready?
allow you.
Are you ready, Steve?
Elliot, you do not need to read the rule to me. You've already done it, and I'm telling you right now, I'm not allowing any questions. So if you want to raise that with the judge, you can. But if you want to continue with the deposition, you can go ahead and ask questions about this case. I've allowed you to do 2.5 hours of questions about Sarah Cherry. I'm being instructed by the attorneys who represent the General Assembly in the Sarah Cherry case to not allow any further questions. So I have no choice but to not allow that further. So you can read the rule all you want, but it's not going to change my position.
You haven't answered my question, Steve.
I'm not going to answer your question. I'm asking you to move on. If you want to stop the deposition here, you can, but I'm saying move on to the subject matter of this case.
Are you done talking, Steve?
Yes. Obviously, I'm done talking. But I'm not going to sit here and listen to you lecture me about the law because I'm very familiar with the law. I've been practicing for 33 years. I've told you what my position is.
Steve, stop talking. Stop talking. Stop ruining my deposition. Stop this right now.
Wow, I can see what they mean by hostile and aggressive behavior.
Pretty scary stuff, isn't it?
Okay, I'm going to do this right now again for you, the third time. Remind me again, how many years have you practiced? Is it 2 decades or 3?
33 years.
Congratulations. All right, so you should know this one by heart. Quote, a person, you're a person, I believe, may instruct a deponent not to answer only when necessary, first, to preserve a privilege, second, to enforce a limitation ordered by a court. I don't see in this rule, Steve, any language that says that you can instruct a deponent not to answer to enforce a limitation ordered by some guy who might as well be on the street, on High Street. I can go down to High Street and get somebody too and ask them if I can continue asking questions, right? Would you like me to do that? I'm going to continue my deposition, Steve, and you can do whatever you like.
You are recording this, right?
Yeah, except
I'd like to request a copy of that recording today.
I think that we've stipulated that they're not going to be used in evidence, but I'd be happy to use them. You know, whatever. If you want to,
I would like a copy of the recording today.
if you want to terminate the stipulation, we can do that. Okay. Are you ready to
Will you
continue?
honor my request to give me a copy of the deposition today?
The deposit or the
recording today?
if I could figure out how to get it off of my device, I'd be happy to do it.
Okay, thanks.
Okay. We were just looking at the third bullet on the second page.
At the instruction of counsel for the General Assembly who represents General Assembly in the EEOC proceeding, I instruct you not to answer any more questions about the Sarah Cherry case.
Okay, I think we need to call the judge.
The judge is not going to be available to take this call. You can raise it by motion. You have until 5 o'clock to complete the deposition. If you want to use it for that purpose, then that's fine. But I would say ask the questions about this case. Did you get that down?
Yes, I did.
Okay.
Welcome to the Ohio Court of Claims. To check the status of your case, download court forms, and obtain answers to frequently asked questions, please visit us on the web at www.ohiocourtofclaims.gov. Otherwise, you can choose from the following options. For general information, please press 1. If you are calling about an Ohio Crime Victims Compensation claim, please press 2. For all other questions, please press 3 or stay on the line and one of our staff members will assist you. Ohio Court of Claims.
Yeah, hi, this is Elliot. How are you?
Well, how are you?
I'm good. By the way, are we still on the record?
Not if all counsel
Can we-
are not, I need all counsel in the room.
Yeah. Hi. Can you please give me the chambers of Judge David Kane?
He's not available right now. Can you do you have a case number or something I can try and help with, or I can get a message to the right person?
I'm happy to give you a case number, but is there a staff attorney available by chance?
They're not available for phone calls. I need to get some context.
Okay. Well, here, let me.
I think you raise it via motion.
Okay. Just I'm gonna call you back. Can we get back on the record, please? Are we on the record? Mm-hmm. Okay, great. Thanks. So I'm calling the court right now.
I thought you just did.
Welcome to the Ohio Court of Claims. To check the status of your case, download court forms, and obtain answers to frequently asked questions, please visit us on the web at www.ohiocourtofclaims.gov. Otherwise, you can choose from the following options. For general information, please press 1. If you are calling about an Ohio crime victims compensation claim, please press 2. For all other questions, please press 3 or stay on the line. Ohio Court of Claims.
Yeah, hi, this is Elliot. How are you?
Hi. Hello. How are you?
Great. So, is Judge David Kane available by chance?
He's not available. If you want to give me a little bit of context, I can route this issue to the right person.
Yeah, great. Yeah, so I can give you the case number if that's all right.
Yeah.
So the number is 2024 798 JD.
Okay. All right. And what is your question or issue?
So we are trying to do I am trying to do. This is Elliot Forhan, by the way. I'm the plaintiff in the case. I am trying right now to depose a witness, and my opposing counsel is in violation of the civil rules, instructing the witness not to answer my questions. And so I wanted to speak to try to get the judge on the phone to get a ruling with respect to these improper instructions to the witness.
And it's my position that he should file a motion if he wants to do that, a written motion with the court.
Okay. And you mentioned deposing, and is that for this case in particular?
Yeah, it's the witness is the name of the witness is Allison Russo.
Give me a moment to read because I see a couple motions filed. I'm just trying to get caught up here. Okay, so we had, and it looks like you filed, right, a motion for leave.
Yeah, but none of the pending motions relate to this issue.
And the voice,
my point is that-
wait, hold on, Steve. The voice that you hear, the other voice is Stephen Funk. He's the counsel to the defendant.
Okay. Essentially, you're in the middle of some sort of proceeding or what have you.
A deposition, yes.
A deposition, okay. And you're not in agreement with what's going on with opposing counsel, am I right?
There's a dispute. There's a dispute, yes.
Okay. I mean, everything here has to be done in writing. You know, I don't know what it is, what you're seeking to happen exactly, but everything has to be done in writing and filings. And they go directly to the correct staff attorney, you know, to review what's going on and to make a determination on it, the judge as well.
Okay. I mean, it is in my experience, it is normal that when a deposition is in progress, that if the judge or a magistrate is available to make a ruling with respect to any dispute that may arise, that is a common practice.
But she just said the judge is not available.
I understand, and I'm just clarifying
and
for the
it's
clerk.
the general practice of the Court of Claims to file written motion.
Okay. Well, in any event, if it is indeed the policy of the Ohio Court of Claims that they do not make, that they do not, make decisions with respect to any real-time disputes.
No real-time decision can really be made. I mean, unless you're in the middle of a hearing or mediation or some, where all parties are involved and completely in everything that's going on.
Yeah.
But unfortunately, that's not the situation.
Yeah. All right. Well, I really I do appreciate your time. Thank you. And we will follow up. Okay.
Okay. Yep. No problem.
Okay. Take care. All right. Bye.
Just for the record, we're at 3:37 p.m. Go ahead.
Are we still on the record? Okay, thanks. You said that you have fired employees before and limited their duties, right?
I don't recall saying that.
It was during one of your previous depositions.
We just agreed that it would not.
I have questions following up on that, the answer that she gave. I just want to confirm that you remember that.
So in terms of outside of the House of Representatives, yes, yes, I have had to terminate employees in the past.
Sorry, I forgot to. Hang on, sorry. Whom have you fired?
I don't recall specific names.
Whose duties did you limit?
We're just talking about prior to her being at the General Assembly with other employers. And other
I didn't say anything like that. No.
I think that's how she answered, but go ahead.
Okay. Well, again, outside of the House of Representatives, I've had certainly employees that have worked for our company, as well as me personally, that we've had to terminate employment or ask for resignation.
Do you have any names of people?
No, I don't.
And so you can't say whom you fired, and you can't say whose duties you limited. Is that correct?
Outside of that's correct. Yes.
And you can't say because you don't remember. Is that right?
I don't recall all the details.
Including their names. Is that right?
That's correct.
Okay. Why did you limit their duties?
Well, if they were terminated or asked to resign, I'm sorry. What do you mean limit their duties?
So you said at one of your previous depositions that you have limited the duties of one or more employees in the past. And so my question is, why did, with respect to those situations, why did you limit their duties?
If certainly if employees are not performing their work duties or performing them well, that would be cause or reason to limit work duties.
How did you limit them?
Again, I don't recall.
Did you limit your employees' duties by not speaking to them?
Again, I don't recall.
Did you shun any of your employees?
I have not shunned employees.
You said that you sometimes don't like the actions of Jason Stevens' chief administrative officer, right?
Objection.
If you are referring to Kim Ziano, is that who you're referring to?
That's correct.
I don't always agree with every action of the House majority.
What actions of Kim Ziano did you not like?
I don't recall specifically.
Has Deanna Herbert told you and other members that women are targeted for discipline by Kim Ziano?
I instruct you not to answer that question. It relates to the Sarah Cherry claim.
Who is your employer besides the House?
Outside of the House, I have been employed and remain employed with Kennel and Associates.
Have you ever been deposed other than the depositions conducted by me?
No.
What work do you do for that employer?
I am a consultant.
What is your annual compensation?
Objection.
I have to think about this because currently it is somewhere over 100,000.
Can you give me a general sense of how much over 100,000?
No, I can't.
How is this even relevant to anything?
Is
This is
it
personal questions about her compensation.
Steve? Make the objection
I'm
is
here to
that
protect her against you abusing her for political purposes.
the objection is to be stated non-argumentatively. This is you're doing talking objections the whole way through here. Okay, it's all in violation of the rules, and you should stop it right now. Make the objection, and it's done, and the answer
I have
proceeds.
made the objection.
Okay, then the answer proceeds.
My compensation I can't recall right now. My compensation depends on the percentage of my time that I work there, which fluctuates depending on what's happening with the legislature. Certainly when I was the House Minority Leader, it was less. Now it's more, but it fluctuates.
Is it more than $1 million per year?
No.
Is it more than $500,000 per year?
No, it is not more than
Is it more than $300,000 per year?
No.
Is it more than $200,000 per year?
No, it is not more
Is it
than
more than $150,000 per year?
Objection.
It is, I do not believe it is currently more than 150,000.
Okay. What are the benefits?
Objection.
What do you mean by benefits?
Of your employment with Kennel?
Yes, what do you mean? Do you mean?
And benefits of your employment agreement?
I have health insurance. I have a retirement plan. I'm sure I have access to dental coverage, eye coverage, mental health assistance, behavioral health assistance. That's all I can recall at the moment.
Do you have any other
tuition reimbursement, but I don't use that for myself.
Do you have any other compensation such as profit sharing?
No, I do not profit share with that company.
Could you explain to me why this is relevant? I mean, why you're actually even getting into this?
Make an objection, and we're going to keep this deposition going, okay?
Well, I don't think so. If you're going to continue on asking questions that don't relate to this case, I mean...
we're getting, getting closer for me to just going straight over to disciplinary counsel right now, honestly, call yourself a lawyer.
Are you
Seriously.
threatening me again?
Absurd. You're doing, the job you're doing right now with respect to the rules is disgraceful, frankly. Can we please continue? Are you responsible for liabilities of the company?
No, I'm not responsible for liabilities of the company.
What are the sources of revenue for the company?
All right, let's take a break. If you refuse to ask questions about the case, I'm not sure why we're here. You have an opportunity to ask questions about this case.
It's my deposition. We're good? All right. What are the sources of revenue for Kennel?
As I'm aware, grant funding, or work through grants and works through contracts with government agencies.
Is it only the federal government whom your employer is paid by?
I don't know that to be true. It's mostly federal government. There may be one or two projects that involve state contracts as well.
What percentage of Kendall's work is funded by the federal government?
I don't know
Objection.
off the top of my head.
Is it how many people work at the company?
I think we're somewhere around 20 to 30.
Are you in leadership of the company?
Yes, technically I'm considered in leadership.
Has Kendall ever been involved in litigation?
I'm sure they have been involved in litigation.
Has Kendall been at risk of being banned from the federal vendor list?
I don't know.
Was Kendall prosecuted by the United States Department of Justice?
I don't know.
Was Kendall threatened by the U.S. Department of Justice?
I don't know.
What was your involvement in the settlement with the Department of Justice and Kendall?
Objection. I'm not going to, no further questions about Kendall because, again, I don't represent Kendall. You're asking questions about Department of Justice that I have no understanding or knowledge about. And so if you want to ask questions about this case, we're here to answer your questions, but I'm not going to let you ask any further questions about Kendall. And you can object all you want, but I'm calling it off on that as well.
You don't get to do this. This is my deposition. Your objections are in the record, and that's the end of it. We are continuing with the questions.
I instruct you to stop it. Do not answer any questions about Kendall. I do not represent Kendall. You want to ask questions?
This is not how any of this works. This is supposed to be as if we were in a courtroom in front of a judge. This would never fly. No judge would let any of this happen, and you know that. That this deposition you have ruined.
Why'd you ask questions about the
Worthless.
case, Elliot?
Worthless.
We've been here 3 hours. You haven't asked a single
How you ever get a fee in your life, I'll never understand. How much is your house worth?
Objection. Do not answer that question.
Oh, really? What's your list now? What's your list of topics that I can't ask questions about, Steve? What's the list? Tell me. What's on the list?
I don't have to sit here and take abuse from you. I can see now how you respond. So if you want to ask questions about this deposition, we're here to stay. If you don't want to ask questions about this case, then we're calling this deposition conclusion. How do you
Sorry.
want to
What are you doing right now, Steve? Are you and your witness getting up at this? It wouldn't be the first time that this witness has walked out on a deposition. Did you know that?
I'll give you one more chance. Do you want to ask questions about this case or not?
You don't have the power to tell me what questions to ask. You can instruct her not to answer on 3 grounds. None of those grounds applies right now. So what are you doing? Are you getting up and leaving, or am I continuing with this deposition?
I'm going to videotape you while you scold me.
Yeah? You like that?
Yeah, actually I do.
I'm sure you do.
I don't think I've ever had that.
Oh boy,
in 23 years as a lawyer. So.
Okay. Ms. Russo, how much is your house worth?
I instruct you not to answer that question.
Okay. So back to exhibit number 3. On the second page.
Exhibit 3 relates to Sarah Cherry, and I'm answering any questions about Sarah Cherry. I've already made that clear.
On the third bullet down, the memo reads, quote, Friday, June 30th,
absent 2.24 hours with no notice, not scheduled off. Is that accurate?
I instruct you not to answer that question. I've already made clear our position on that. The court, you called the court said file a written motion. Resolve it that way. If you would like to ask questions about this case, we're here to answer them.
Ms. Russo, did I ever touch anyone?
I don't know.
Did I ever put my hands on anyone?
Sorry. Can you be more specific?
Talking about as a state representative or like in general in your entire life?
Confused by the
Can you
question.
please let the witness answer the question, Steve? You embarrass yourself anymore.
You said, did I ever touch anyone? That's a
Steve,
ridiculous
please
question.
let the witness answer the question.
I assume you are a human being and you have touched someone in your life.
Did I ever put my hands on anyone?
I assume as a person you put your hands on someone.
In the way that Sarah Cherry alleged that Jordan Plotner put his hands on her.
Okay, no further questions about Sarah Cherry. We're going to instruct you not to answer. You continue to engage in this line of questioning.
I'm asking her about, first of all, everything you're saying is complete and utter nonsense and would never for a moment, and believe me, there will be motions before the court, there will be complaints to the disciplinary council. It's all coming, okay? But for the record, I was asking her about me, Steve, by analogy. Or maybe that's a little too complicated for you.
You said Sarah Cherry and Jordan Plotner.
I said.
Okay, I think we're just going to have to raise this with the court and then we'll just deal with it at that point.
We're going to do what?
We're going to call the deposition off. We're going to sit here and be berated.
Okay, so for the record, opposing counsel and the witness, Allison Russo, are ending the deposition before time. That appears to be what's happening. To be clear, I am protesting. I am still here. This is Elliot Forhan talking, who's supposed to be taking this deposition, and I have many, many more questions that I would like to ask. So, if that's what's going on right now, then
are you going to ask questions about this case, or are you going to keep going back to the Sarah Cherry case? I've already made the position clear that we're not going to answer questions about that. That is something that I've been instructed by the attorney for the General Assembly in that case. So I can't just keep going back and telling her not to answer. If you want to ask questions about this case, we're here to answer them. I've said that multiple times.
you just trash my deposition is what you came here to do today. Isn't that right? That was what you came here to do today.
Actually, no. I came here.
Yeah, but you didn't come here today to follow the Ohio rules of civil procedure. I'd encourage you to reconsider your choices in life.
For 4 hours, you deposed David Myers. You asked questions about the case. I did not object very much. I objected when there was an objectionable question. Here, we've spent 3 hours, and you haven't asked a single question about the case. So it's a completely different situation. And I don't have control over it. I did allow you to answer questions about Sarah Cherry, but I've now been instructed to cut off that line of questioning because it is the subject matter of a different case. The General Assembly is represented by different counsel who is not me. And so I have no ability.
This deposition it should be called the Stephen Funk deposition because you have talked for about half of it. Okay? Stop talking. Exhibit 3.
I would like the record to reflect that I feel very uncomfortable with this counsel, Mr. Forhan. He is yelling, he is being demeaning, and very hostile.
Exhibit 3.
Okay, we've already said we're not asking questions about Exhibit 3, so we are done. You can raise a motion with the court I've sat here for 3 hours. I've allowed the witness to answer questions, but Mr. Forhan continues to persist in asking questions about the Sarah jury. So if that's the case, then we're not going to continue to be berated and attacked in a hostile manner like this. Thank you.
For the record, I am protesting what these people are doing in leaving the deposition for the second time for this witness. Second deposition she's walked out of.
We will review the transcript. I'd like a copy, and I'd like to have that on an emergency basis, if that's, or expedited.
I could probably have it by Monday. I can't have it by tomorrow.
Yeah, no, Monday's fine.
Or Tuesday?
Tuesday's fine.
Okay, Tuesday. It will say Tuesday because I have two other ones due on Monday. Okay, Tuesday. I can have it done. Okay. Oh, did you leave those exhibits?
What's that?
The exhibits for her.
Oh, okay, yeah. Let me go.
Okay, yeah.
Check, see what document we have. I'll be right back.
Okay. All right. Okay, so I'm going to close the record. Did you need to put anything on there other than what you just said? I think you just...
No.
Okay. Do you need either a copy of either of these witnesses?
Sorry?
Do you need a transcript of either Mr.
Oh, yeah, I'm going to want a transcript of each of them.
Of
Yeah.
each one?
Yeah. Thank you. Thank you.
Okay, you're welcome. Do you need yours when I send his out on Tuesday? Do you need yours on Tuesday as well?
I mean, it's not urgent.
Okay.
Yeah.
Because they would charge you for that if you wait
Yeah,
until
yeah.
the regular time.
Yeah, yeah,
you
yeah,
wouldn't
yeah,
get
yeah.
charged that extra fee.
Yeah.
And
Right,
it is
right.
pretty significant.
Yeah, no.
Okay.
Right. Actually, let me hold on actually placing the order.
Okay.
Okay? Yeah.
All right, they'll probably just send you an invoice just for my attendance, and then if you want to order the transcripts later, just
Yeah.
contact whoever
Right,
you talk to.
exactly.
Yep.
Exactly.
Okay.
Thank you. I really appreciate, thank you.
Mhm. No problem.
So, sorry, so you don't have a copy, or
I don't have. I have his.
She took.
They took. I don't know. I didn't see them in her possession. I think they might have been all the papers he gathered up. But
So
you
need to get.
He's coming. He's coming right there. He's got him. I know. Trust me. I do not. I'm the keeper of the record. I'm not leaving without him.
No, I know.
No. He was saying I gotta get him. I'm like,
Yeah, you'll
I
get
will.
them. You'll get them.
I will.
So here's Exhibit 1.
Okay.
Here's Exhibit 2.
Okay.
Here's Exhibit 3. Here's Exhibit
Okay.
4.
All right.
What other ones are there? Do you not have?
We were going to be up to 5, so we're good.
Okay, good.
Yep.
I mean,
Thank you for your help. I appreciate it.
so,
Yeah.
I mean, I'm in a difficult position here. So,
Enjoy the sanctions. That's all I have to say. Like if you can't follow the rules, that's what happens.
well,
Look, Steve, save it for the judge. Save it for the judge.
I want to talk about how we can present this to the judge to try to get.
You can present it however you want.
Okay,
Do whatever you want.
I can see that you're angry right now, but let's just
Well, yeah, you fucked up my fucking deposition.
let's talk. No, I didn't.
Yes, you did.
I let you